Silence, court rise.
Appeal in the matter of McGaw and the Welsh Ministers and another.
Yes, Mr. James. I can tell you that we have read the judge's judgment, the inspector's decision letter, and the skeleton arguments.
My Lord, I'm very grateful. I appear, as you'll know, for the appellant Welsh Ministers, my learned friend Mr. Jones for the respondent Mr. McGaw. As below, the interested party, the Council of the City and County of Swansea, have not appeared and are not represented. As your Lordship will know from the skeleton arguments, the narrow issue in this appeal is the height restrictions contained in Class E of Schedule 2 of the Town and Country Planning General Permitted Development Order 1995, and in particular where, for the purposes of calculating the maximum permitted height of a building.
If I may ask an impertinent question, why are Welsh ministers so exercised about this?
My Lord, the issue is the correct application of the height limits and whether the nuisance which the height restriction seeks to address is properly being dealt with.
I follow that. I mean, this building is going to be completely hidden by the boundary wall. If it's built according to the way that Mr. McGaw wants to build it.
Well, according to the plans, yes, but the relevant test for permitted development isn't visual amenity from neighbouring land, but rather a strict application of the height requirements, and it's for that reason that the application and the proper measurement of height, we say, remains relevant and important.
At some point in your submissions, Mr. James, you might like to address us as to what you say is the mischief of this carve-out from what is generally permitted under Class E.
My Lord, yes.
You don't need to say it now, but...
Well, the short answer, which I'll return to, is that it's the protrusion above ground level of buildings.
Yes, but not for its own sake. Presumably, so that it shouldn't spoil the visual amenities of the neighbourhood.
Well, yes, that is right. That's the policy background, as it were.
Yeah.
To
so if it's concealed from at least one neighbour by an existing structure, for which no planning issue arises, one does slightly wonder. Now, of course, the height restriction is there, and you can't say, well, just because there's a boundary wall that's higher, I can go a little bit higher than the permitted height, but it might help, it might possibly help to cast some light on the question of the critical phrase immediately adjacent.
Well, yes. I hope that large, full-size A3 plans.
Yes, we have them on the bench now. Thank you very much.
I'm very grateful.
We have. I should have said we have been studying the plans as well as we had them before in A4 format.
Yes, and my Lord, having
some of them, I think we may have had in A3 format, but nothing like as clear as this, and it is certainly of considerable assistance to have these better copies.
Well, yes, I can only apologise that they weren't included in the original bundle. Having discussed those new plans with my learned friend, however, there's nothing that materially changes.
No.
They are better quality, larger plans.
Just that we can read them better.
Yes.
Further arising from discussions with my learned friends, we're in agreement that if your lordships find that the judge erred in his determination of the location from which to measure height, then the appropriate relief is to set aside clause 2 of this order, which appears at page 58 behind tab 9, the core bundle. That's the direction that the certificate be granted. However, in the light of the judge's other conclusions, I'm bound to concede that the inspector, Mr. Nixon's refusal is in any event quashed and the matter is remitted to a new inspector.
Will be the third or the fourth?
It will be the second on these plans. It will be the third, as I understand it, overall, my lord.
Fourth, I'm afraid.
Fourth.
Yes.
Fourth, I thought,
Well,
yes.
the first
Yeah.
one
Forgive me,
was
yes,
set aside
remitted
on
from
JR.
His Honour Judge Keyser,
Yeah.
Queen's Counsel, the first time.
Yeah.
Apologies, yes, the fourth inspector. The only other matter, my lords,
I does wonder whether it wouldn't be easier for Mr. McGaw to apply for planning permission rather than to go through all this again. Anyway,
my lord, the only other matter which arises by way of introductory background matters is in respect of the March 2020 application.
yes.
Those plans are at tabs 14 to 25 of the supplementary bundle.
Yeah.
I need not take your lordship to those plans at the moment.
Right, and that's an identical building, but it's moved back from the wall
Well,
by
it
150 millimetres.
Indeed, and the proposal is that there will be backfilling within that 150 millimetre space, and the Welsh Minister's position is that in terms of height requirements, the amended plans or the new proposal would comply with the height requirements in Class E, subject to a determination on whether that is an artificial device, and that is a matter which I'm instructed not to concede, as it's a matter properly for either the local planning authority or an inspector in the first instance.
Right.
My lords, if I may then take you to the new plans, which are numbered as they were in the supplementary bundle. Number 1 shows the location of the property and the boundary and the curtilage, which isn't an issue between the parties. In this case, plan number 5 shows the proposed garden room constructed in the southwestern corner of the property. Page 6 shows a side profile which has the garden wall, the boundary wall in the background, the proposed garden room, and then a dotted approximate garden profile of the Mr. McGaw's garden, with just to the left at that beginning what is said to be the original garden profile pre-excavation. And then on page 9, your lordships will see the garden wall viewed, as it were, from the neighbouring property, which has the approximate topography profile of the neighbour's land against the boundary wall, and very faintly the outline of the garden room behind it. And that is essentially the plan from which the measurements the judge took. The matter then came before Mr. Nixon, and his decision is at tab 11, page 21 in the core bundle, and materially what Mr. Nixon found at paragraph 7 was that backfilling would not be possible on the building's southern flank. That's the flank which abuts, as he found it, the existing brick boundary wall. Mr. Nixon went on to find that therefore it was the existing ground levels which would constitute the level from which the relevant building height calculations should be made. That, of course, was found to be incorrect by His Honour Judge Jarman, Queen's Counsel, as the test is a prospective test. In any event, however, the fact that the garden room would be built abutting the existing brick wall was not an issue. I'm bound to note that in paragraph 9, the word adjoin is used in place of abutting, but for reasons I'll come on to, a but or a join makes no material difference in this.
What did Mr. Nixon mean in paragraph 7 by saying that the existing ground levels immediately adjacent to the southern flank of the building constitute the level from which the relevant height calculation should be made? What is he referring to as being the existing ground levels immediately adjacent to the southern flank, given that in the same paragraph he's just said that you can't backfill because the southern flank is going to abut the boundary wall?
Well, yes. The reference there, as I understand it, is to the ground level as they currently are. So the excavated area of land before the garden room is built. And it's for that reason that His Honour Judge Jarman, Queen's Counsel, found that on that basis he'd erred, because Mr. Nixon had determined the height with reference to the current ground levels.
And that's not appealed.
It isn't, my lord, no.
But, I mean, even on that basis, it's puzzling that he should talk of an existing ground level immediately adjacent to the southern flank of the building, because immediately adjacent to the southern flank of the building is the boundary wall.
Well,
I mean, it's not going to, I mean, that reasoning is puzzling. It may come close to the issue in the case, but what he said about it isn't, of course, perhaps particularly to the point.
My lord, we say that because the garden wall and the boundary wall abut or adjoin as opposed to being a single construction, there will be some, albeit minimal, there will be some adjacent land from which ground level may be taken, may be measured.
On Mr. McGaw's side of the wall.
Sorry. Enough to take a measurement from?
Not necessarily enough to measure physically from, but enough for that ground level to be ascertained.
Enough for you to know exactly where it is?
Well, we say that is the case because there are two separate walls being constructed which abut or adjoin and are not a single piece of construction.
So there will always be a sort of razor-like separation between the boundary wall and the wall of the garden room. And so you say, however thin that is, that will lead to there being a surface.
Well, yes, and I accept that, and as the submission was made below, and again I accept that it may be bridged by mortar in places, it may be that it is the construction of the garden room may mean that it is razor thin, but it is nonetheless a space. These are two walls which abut. It is not a single wall. And in any event, I say that at the southeastern corner of the building, a measurement taken at that corner can properly reflect the ground level in that gap at that very narrow particular place, that is on the corner, which remains the southern wall of the boundary room.
But your point, I think, is that there's the height restrictions are only a tool for measuring whether a building comes within the scope of Class E. It doesn't matter that the gap or the point from which you're measuring has no practical use after the building has been erected. It is simply a reference point for measuring the height of the building.
Well, Lord, yes. The order is a tick box exercise.
Yeah.
And once that box is ticked, then the measurements are of no further relevance. And the importance, I say, that there are two separate structures, the boundary wall and the garden wall, is that there must therefore be ground level which is capable of being measured, even though it is not ground which is capable of being used or is of any particular significance outside of the context of measuring for the purpose of the height restriction. And I should note that Article 1.3, of course, is the prism, as it were, through which the relevant location for taking the measurement is to be viewed. My lords, that's at page 21 of the authorities bundle. And that states, unless the context otherwise requires, any reference in this order to the height of a building shall be construed as a reference to its height when measured from a ground level. Goes on to define ground level as meaning the level of the surface of the ground immediately adjacent to the building.
What does the context require in this context?
The starting point is that the ground immediately adjacent to it is of particular relevance, because that phrase is repeated at page 26 in the authorities bundle in paragraph E1.
Yeah.
So we're not concerned here with the height of a building per se. We are concerned with the height from the ground immediately adjacent to that part. It's agreed between the parties that the final phrase of Article 1.3, which is the benefit of the doubt that you measure from the highest part of the land, doesn't apply. And so the material question for the purpose of Class E is from each point, in respect of every part of the building, from each part around it, it must comply with the height requirements. And so,
for Welsh purposes, we ignore all the words after machinery in question. Is that it?
my lord, yes, or whether the level of the surface ground on which it is situated or is to be situated is not uniform. That's essentially ignored.
That was excluded in relation to Wales.
For the purpose of Class E.
For the purpose of Class E. Well, I see. Yeah. So, and you pointed to the words at the beginning of 1.3, unless the context otherwise requires. Do you say that the context does otherwise require in this case?
My secondary position is that it does. If there is no ground level immediately adjacent to, and I say that if my laws are against me on there being a gap which is sufficient for the purpose of measuring, then adjacent ground level must mean either the wall or, as the learned judge found, the neighbouring garden. I say that the context does require otherwise, and the context is, firstly, that Class E specifically deals with development, in this case a building, within the curtilage of a dwelling house. And so the significance of the circumstances, the level of the land within the curtilage of the dwelling house is of particular importance. Secondly, the point which I made in respect of ground immediately adjacent to being repeated in Class E, identifying the particular importance that it's the height above ground level of the building which is important, not its height generally or visual amenity or whether it overbears on a neighbouring property. It is, to put it bluntly, how much does that building protrude from the ground in the location in which it sits? Because, my lords, Class E, in any event, and it isn't relevant to this case, but in the broader context it is relevant, that a building would have no more than one storey is in any event a restriction imposed by Class E.
Yeah.
So the height restriction doesn't prevent a 2, 3, 4 storey building from being constructed. It is there, I say, to prevent a building from protruding more than 2.5 or 3 metres from the ground in which it is placed.
Yeah.
The internal height may be greater if there's backfilling or if it is sunken.
Yeah.
But it's the protrusion above ground level which I say is of particular importance.
So you're saying that on no basis can it be legitimate to look at a ground level, the level of ground outside the proposed developer's own ownership,
My lord, yes, that's the basis.
outside the curtilage.
My lord, yes.
And that would be the case even if there were no boundary wall, the proposed building were proposed to be built up to the boundary, so that in the ordinary use of language, the ground immediately adjacent to the proposed building would be the neighbour's land, the other side of the boundary. You say that would not be a legitimate point to measure from.
My lord, in those circumstances, my position or my submission would be that, as in this case, the southeastern corner of the building would provide a point at which the height from land which is adjacent but is it within the curtilage could be taken from.
But that depends on the configuration of the particular building, doesn't it? I mean, you have to postulate a building where there is no gap in order to answer my lord's question. What if there is a building which goes right up to the boundary, whose flank wall is the boundary? Where do you measure from then?
Well, in my submission, it would be from either, as in this case, where there is a corner and absent a separate boundary wall, the building will itself be, as it were, the retaining boundary wall for the length of here, the southern elevation. But when the building stops, then either there is a boundary wall or there is no wall and you simply have the boundary.
But if you've got sloping ground, as you have in this case, your corner of the building may be at a different level from the rest of the building along its flank.
Well, yes.
But you would say it has to be satisfied at all points along the boundary, because you haven't got the highest part of the surface point.
That's correct. And in this case, the entrance to the garden building being, or the garden room being on its eastern elevation, that means that that's where the ground level is at its lowest, and so necessarily the height at its highest, and that's the measurement to be taken.
Yeah.
Alternatively, I do say that it's possible to deem the height with reference to where the wall is situated on the land within the curtilage. And I say that a development which is built on the boundary, the context of that development would require the local planning authority or the inspector to deem what the ground level immediately adjacent to that wall would be.
How would that be done?
In effect, by looking, my lord, I say, at the construction of the wall in the excavated space.
So down to the footings? Down to the excavated area? I mean, if we're talking about protrusion above ground, you don't go down to the foundations of the wall.
Or no, in my submission, it would be what is deemed to be the ground level, the original pre-excavation level.
So that's where the boundary wall meets the surface of the land.
Well,
Is it?
essentially, yes.
which is actually the neighbour's garden.
On one side.
Out with the curtilage of the dwelling house which is being developed, yes, but
where
within the curtilage.
That's where you could identify it.
My lord, yes.
And so you identify it outside the curtilage and deem it, in effect, to be the same level within the curtilage.
My lady, yes. You extend it and deem it.
Back through.
Where it would meet is...
So if you do that, then what's wrong with the judge's approach? Because he said you measure from the neighbour's garden. And you're saying, well, yes, that's right, but by a process of deeming, you transport the measurement from the neighbour's garden on one side of the wall to the developer's garden on the other side of the wall. But that would mean the judge was right, wouldn't it?
My lord, on the facts of this case, I say that it doesn't. Firstly, because I say there is a gap. Secondly, I say that in any event, because the wall is present and the wall is a separate, in this case, pre-existing structure, but in any event, if it were a separate structure, the point in my submission stands.
No, I understand that you say there is in fact a gap on Mr. McGaw's side of the wall, and no matter how razor thin, as you put it, and that's simply a measuring tool and you can use it. What I haven't quite understood is your secondary position, which seems to be, well, as you said to my lady, that you can measure from the neighbour's garden and then you would deem that height to be the height on Mr. McGaw's side of the wall. If that's what you're doing, then the judge's solution, which is to say measure from the neighbour's garden, is correct, isn't it?
Forgive me, it's measuring from, in this case, Mr. McGaw's garden and deeming that to be the height of the neighbouring garden.
Oh, I see. Deeming goes the other way.
My lord, yes. My apologies.
Yeah, I see.
But my secondary, the fallback position, my lord, is that even on a strict analysis of ground level immediately adjacent to, it is incorrect to say that the neighbour's garden is immediately adjacent to, because there is a wall in between the structure and that garden. And the significance of that is really made out by the examples which your lordships will have seen in my skeleton argument, that the presence of a retaining wall means that the level of the land the other side of it doesn't necessarily bear any resemblance to the level of the land where the garden room in this case is being built. It could be higher, which here gives Mr. McGaw, on the judge's analysis, the benefit of that increase in height. But equally it could be lower. Yeah. And if the ground level is 2 metres lower in the neighbour's garden, 2.5 metres or 3 metres lower for ease, then it means that Mr. McGaw wouldn't be able to build anything, because...
Of course, it might not be safe to build at that point, unless you've got a very powerful retaining wall.
Well, my lord, yes, save, of course, that it's development of buildings, enclosures, raised platforms, swimming or other pool. And so, though the point stands, my lord, in respect of garden rooms and construction methods, the point of principle in terms of where the height is taken from, in any event, in my respectful submission, stands good. It is, firstly, a point of certainty, and secondly, a point of fairness, because it isn't necessarily an issue which arises out of malice or out of intent.
No.
Sloping streets gives rise to that difficulty, where there can legitimately and naturally be significant differences in ground levels.
But just to be clear, I'm not sure whether, in fact, your argument in relation to adjacent to depends on whether there is or isn't a boundary wall. I know you said it can't be adjacent next door because there's a wall, but in fact I think when you were, and I just want to be clear about this, whether in fact if there were no wall and there were just some bushes or whatever, there was nothing, in fact you would still say that next door was not adjacent because it's not within the curtilage.
My lady, that's right. And the reason why I say that second proposition is correct is because Class E is to be considered within the curtilage. But on the facts of this case, in any event, if you're against me on that, the neighbour's garden, in this case, with a boundary wall, cannot be considered as land immediately adjacent to, level of the ground immediately adjacent to.
You've drawn attention to the contour at the proposed contour at the proposed construction of the southeast corner. Is that something to which any of the either of the inspectors gave attention? I don't recall.
My lord, it isn't. In respect of Mr. Nixon, of course, it's because Mr. Nixon took the approach that this was the current ground levels which was relevant. It's my understanding that there's no issue between the parties, that it is only with reference to the level of the neighbour's land that the garden room complies with Class E.
Well, it would have to go back to some other inspector.
It would, but
I mean, if you're right in saying that the judge was wrong to say that you measure from the neighbour's garden, then I think although you accept that Mr. Nixon's decision remains quashed, there would have to be a new decision.
There would be. The point which I was trying to make, but poorly, my lord, was that we don't have the measurements. But as I understand it, the argument isn't, in any event, a measurement could be taken from the southeastern corner and the garden room would comply. And that's because, well, that's evidenced in part, I say, because the proposed amended garden room is to move it in and to backfill. I say that, of course, with the caveat that my learned friend's secondary argument is to take the height from the top of the garden wall. So that is an alternative where the garden room would fall within within the height requirements of Class E.
Well, that argument obviously faces certain problems.
My lord, you have my point in terms of Class C, the context within which it sits, and that is its provision for development within the curtilage of a dwelling house, and I submit that is particularly important. I've referred to the height requirements being specifically set out as being measured from the surface of the ground immediately adjacent to that part. These aren't height requirements in the broader sense. They are, as I've indicated and in my submission, significantly a height requirement as to the extent the development protrudes from the land. It is, and in my submission, the inclusion of those words, together by way of background evidence or background matters, the fact that the benefit of the doubt doesn't apply to Class E, weighs in favour, in my submission, of viewing Class E almost as a standalone regime for measuring heights. And Article 1.3 assists, but the context in Class E is, I say, essentially a standalone regime for measuring protrusion from the level of the land in which the development sits.
So if that's right, are we applying the definition in Article 1.3 at all? I ask that because you would seem to place some reliance on unless the context otherwise requires.
Well,
but as you quite rightly point out, the method of measurement is repeated in Class E. So are we applying the definition, the general definition?
My lord, we are.
We are.
The point is that the context may, in other circumstances, lead to a departure from the strict application of land immediately adjacent to.
Right.
And I say where those words are echoed, the context is unlikely.
Yeah, I follow.
As if Article 1.3 alone were being viewed, one may with more ease depart from those words, where those words form the part of the restrictions themselves. I say particular care ought to be exercised in assessing the height or the relevance or the application of the height.
Yes.
So turning then, my lords, to the judge's conclusion below, the starting point, my primary position is that as a matter of fact, in the circumstances of this case, there is a gap. It is not set out in the plans, they are not construction drawings, and it is not my case that there need be any criticism of those drawings. However, the factual findings are that Mr. Nixon found that the walls would be abutting or adjoining. His Honour Judge Jarman, Queen's Counsel, found that the garden room and the boundary wall, that is, would abut one another and would be flush. And the point which I've already made is they are two separately constructed walls. It is not a single construction, and therefore there must be a gap between them.
So we're really concentrating on paragraphs 36 and 38, aren't we, in the judge's judgment?
Lord, yes, paragraph 37.
Yeah, 36, 37, 38 is the critical part.
Yes, and 37 refers to Mr. Nixon's findings and the plans, and finds that there is no room to infer a gap, or at least not the extent of the bottom of the gap could be sensibly regarded as the ground immediately adjacent. And in my submission, the reason that's wrong is because these are two separately constructed walls, and in the context of having to measure the protrusion of that southern elevation of the garden room from the ground on which it sits.
Is that what Mr. Nixon meant in paragraph 7 when he talks about existing ground levels immediately adjacent to the southern flank of the building? Is he acknowledging that there is or maybe a gap, even if it is wafer thin?
It's the relevant area, though I don't think I can stretch Mr. Nixon's reasoning. I don't think I can stretch Mr. Nixon's reasoning that far, because of course the approach that Mr. Nixon applied wasn't a prospective one, and so
yes, quite.
I wouldn't be able to say that paragraph 7 imagines the wall being there, because of course, as the judge found below, that's not the approach that was taken wrongly by Mr. Nixon. And so what I say is that essentially paragraph 37 of His Honour Judge Jarman, Queen's Counsel's decision is incorrect, because there is ground level. It is immediately adjacent, of course. It's whether it's ground level which firstly exists and secondly is capable of being measured, and I say it does exist.
So, I mean, your point really is focusing on the last sentence of paragraph 37, when he says there's no room to infer a gap, or at least not to the extent that the bottom of the gap could be sensibly regarded as the ground immediately adjacent. Your point here is, well, this is only for measurement purposes. It doesn't matter whether there is, as it were, a real surface. This is simply a measuring device.
My lord, yes. That's the point. It's a location at each point around the garden wall for taking a measurement. It needn't be useful, it needn't be of significance to the construction, but if there is land adjacent to, then it must be measured. And again, the context is important, because in my respectful submission, it flies in the face of the height restrictions in Class E to say, well, that land which is immediately adjacent to can't be measured, and so we'll take it the other side of the wall. For the reasons of fairness I've already alluded to. And again, I say in practical terms, the southeastern corner is capable of being measured. The height of the southern elevation at that corner may be measured. If not, it is an exercise which has to be carried out with reference to the level of the land as it is, or as the building's proposed to be.
Was that submission made to His Honour Judge Jarman? He doesn't seem to have addressed it.
It was made. Paragraph 36 records the level immediately, that there was ground between the two walls.
Yes.
The point about the southeastern corner, my lord, wasn't. I didn't make that specific submission.
Yeah.
But there isn't a separate ground of appeal saying he's wrong to ignore the possibility of measuring at that point.
There isn't, my lord, though I would say that that is simply a practical approach to measuring the location which below I invited the judge to accept as being correct, which is the level of the ground in the gap. In principle, or as a matter of principle, or practical application of Class E, in my submission there's no difference between the reference to the gap as it was below and the specific reference I now make to the southeastern corner. It's the same space, as it were, I would submit.
Yeah, your ground of appeal is simply the judge was wrong in paragraph 38 to say it's the neighbour's land. So I suppose you are able to say, well, there are alternatives. Yeah.
If you're with me on that, that there is rather ground immediately adjacent to the southern wall, then that is, in my respectful submission, the end of the matter. It's capable of being measured, and the garden room is too tall. If you're against me, then it's in those circumstances that unless the context otherwise requires in Article 1.3 becomes relevant, and it's within that context, in this case, that limiting or restricting the measurement to within the curtilage of the dwelling house is significant, because the context, I say, dictates or requires it. The alternatives, then, firstly, the garden wall, and I say that rightly the judge dismissed the respondent's argument on that point. Firstly,
it's not the surface of the ground.
It's not the surface of the ground. Secondly, it gives the benefit of the height of the wall in addition to the height restriction. It's different it's different in substance, in nature, and I say that it's not only in terms of height, but in terms of the visual amenity aspect in particular, flies in the face of the nuisance that Class E seeks to deal with. I've largely dealt with why I say the neighbour's garden is wrong. If you're with me, then on my primary argument, it's not immediately adjacent to, but in any event, I say that the context requires something different. I appreciate that's putting the words back to front, as it were, and the real question is, well, what does the context require? But for the reasons I've set out in terms of consistency, in terms of dealing with the nuisance of how high does this proposed building protrude above the ground level in which it sits, measuring, as in this case, ground level which is higher because of the existence of a retaining wall, in fact bears little to no resemblance or relevance to the level of the land at which the property, or within which the property sits. Not the property, the garden room, the development. And being outside of the curtilage of the dwelling house, I say it necessarily introduces an external factor which is entirely separate. I accept, of course, there may be circumstances where the ground is level, but equally, a wall built on the boundary may be used as, or may operate as a retaining wall, and it's in those cases that the ground level between the neighbouring property and the development, I say they bear no relationship with each other. And the fact that in some cases the land may be level doesn't, in my submission, mean that the context can generally require height to be measured from outside of the curtilage of the dwelling house which is being developed. And finally, the third proposition of my learned friend is that it's the natural level of the land in the vicinity of the southern flank which is sensible, and that has been excavated. I say that is incorrect, essentially because it isn't prospective. It may be a tool which is relevant to measuring the height, but it cannot in and of itself be the area or the level of the land that's used for height purposes, because it isn't prospective. It may be viewed in context as the development is being built, or in the context of plans to determine where the ground level would be, but it can't simply be measured from that area, because that is, I say, the error that Mr. Nixon essentially fell into. I'll deal very briefly with a broad criticism which my learned friend makes, which is essentially you can't measure below the building, you have to measure immediately adjacent to it. The short answer in my submission to that point is that the context requires, in my submission, the height at a point nearest to the development to be taken. And so if that is beneath or below the building, but the measurement is still a fair one of its height, then that criticism largely falls away. And I say that making it clear that a sunken floor, for example, isn't going to mean that the height is measured from the sunken floor as opposed to the higher external ground level. But if there is an internal floor level which identifies or is capable of identifying the external ground level, whereas in this case the gap between the boundary wall and the southern elevation is very small, then in my submission there is no reason to dismiss that as a candidate for measuring the height restriction.
I'm not sure I fully understand that. You've got to find somewhere a point outside the building but immediately adjacent to it from which you can measure the height, haven't you?
My Lord, yes.
So what does anything inside the building
Well,
do to cast light on that?
Within the footprint of the building, I think is probably the correct way of identifying it, because my learned friend's criticism is that certain measurements have to be viewed as being below the roof as opposed to immediately adjacent to the elevation. And if that criticism, for example, is based because there is a protrusion of the flat roof structure, then measuring from the base of the wall to the top of the roof, I say, is preferable to measuring from the end of the protrusion of the roof structure to the ground level where it is there, because what's important is that how far does the southern elevation here protrude from the level of the ground immediately adjacent to it. And if that ground happens to be below the roof, that doesn't take away from its relevance or suitability.
Oh, I see. You mean the relevance of the eaves or something like that?
My Lord, yes, potentially. on the facts of this case, I say it isn't determined.
Perhaps I see what you mean.
But to the extent that the point is taken that something is below as opposed to adjacent to,
below, yes. It's one thing to say it's below the body of the building, but you say it might be below an external higher level protrusion such as the eaves.
Well, yes, that's the point.
Right.
Because on the facts of this case, there is an overhang at one end.
There's an overhang at the eastern end.
At the eastern end, my lord, yes.
Yeah.
If I turn my back for a moment.
Mr. James, I was reading around this subject in the last days, and I came upon something in the Encyclopedia of Planning, Law and Practice, which I dare say is familiar to all planning lawyers. Words of Mr. Justice Goulding in a case in 1973, which are probably not controversial at all. It's common ground that the development order is to be construed in what has sometimes been called in argument a broad or common sense manner. At any rate, in the manner appropriate, as counsel say, to a document framed for administrative purposes, rather than as an instrument couched in conveyancing language. And he says a little later, it appears to me that having considered all, I have to apply myself to the ordinary meaning of the language used by the minister in making the development order. I imagine that's still common ground. It wouldn't take either of you by surprise.
No, certainly what I say the position is.
Yeah, it's a case called English Clays, Lovering, Potchin and Plymouth Corporation in 1973. Maybe of some help.
My lord, yes. Well, if I may deal with that point and the point which may arise from it. In my submission, the submissions which I make aren't ones which are overly technical or require an overly technical approach to measurement to be taken. It is simply a case of identifying the level of the ground. And I appreciate, of course, there are difficulties which sometimes arise, and in this case, difficulties with, well, is there a gap? How big is it?
Yeah.
But, my lord, if you accept that there is a gap between two walls, which I say are separate structures, then I say that it is doing nothing more than adopting a common sense approach to the language to determine that that is the relevant point from which the height measurements are to be taken.
Yes, you say, as I understand it, that in relation to the later proposals, which are set back by 150 millimetres, what's at the bottom of that gap is the surface of the ground immediately adjacent to the building. And the same is true if it's only 1 millimetre.
Well, Lord, for the purpose of Class E, yes, I do.
Yeah.
It is ground level, which is immediately adjacent to.
Yeah. And I think in terms of what Mr. Justice Goulding spoke of, that's also, of course, coloured by the view one takes of the statutory purpose behind these provisions, which you have identified, and I dare say is not in controversy, as being preventing excessive protrusions from above ground level. If you want to do something that protrudes further from ground level, you have to apply for planning permission.
Lord, yes.
Okay. Just as you do if you want to put up a 2-storey building.
Well, Lord, yes. And the visual amenity point is dealt with by that alternative regime.
Yeah.
And so that's why I say the fact that the building in this case is shielded from view by the wall doesn't assist Mr. McGaw, because it's the height requirement, which is, it is, I say, binary.
Yeah.
And it may well be persuasive if a planning application is made that it is shielded from view.
Yeah.
But for the purpose of Class C and these height requirements, that isn't something which can be factored into the measuring of height.
Yes.
I'm great. If I could turn my back for a brief moment. My lords, unless there is anything else in particular that you'd like me to deal with, those are my submissions.
No, very succinct. Thank you very much, Mr. James. Yes, Mr. Jones.
My lady, my lords, the first and primary point is the point that my learned friend advances, that there is a gap, or that there would be a gap between the southern flank wall and the boundary wall. And during the course of my learned friend's submissions, the court identified that the crucial paragraphs are 36 to 38, and I agree, and in particular, paragraph 37, the learned judge below succinctly identifies why my learned friend's argument can't succeed. The first reason is that it is contrary to the findings of fact of Mr. Nixon and contrary to the evidence. Because Mr. Nixon says at paragraph 7, and I agree it's difficult to construe all the sentences in paragraph 7, but one thing which is clear is that Mr. Nixon is saying that backfilling does not assist Mr. McGaw on the southern flank because there is no ground in effect to backfill.
That doesn't necessarily dispose of Mr. James's 1 millimetre point. I mean, you may not, in practical terms, be able to backfill a gap of 1 or 2 millimetres, but he says, well, there is a gap, even if it's a useless gap. All you need, for the purposes of Class E, is a point from which to measure. You don't need to do anything more than measure. And you're measuring vertically, so what happens on the horizontal plane doesn't matter one way or the other.
It's accepted that if there's a 15 centimetre gap, that can be backfilled, and that would come within Class C. It seems to be that the appellant's argument is that as that gap becomes smaller, 10 centimetres, could that be backfilled? Yes, no, that's very much a fact-sensitive issue. We've got no findings of fact as to whether Mr. Nixon thought there was a gap, but a gap which was too small to be backfilled. That's all.
Oh, for sure. Yeah. But as I understand Mr. James's point, it doesn't matter whether the gap is too small to be backfilled in practice. Doesn't matter whether doesn't matter what the width of the gap is, as long as there is a gap, no matter how small, it can do duty as a point from which to measure in the vertical plane. And so the question whether there's anything you can do with it at all, whether backfilling or anything else, doesn't matter. That, as I understand it, is his point.
Yes. Well, my first response, and I think is the response of the judge, is that there is no gap because the findings of fact of Mr. Nixon are that there's no gap. Now, the judge goes beyond that because the judge looked at the plans himself. The court has the plans and the better copies of the plans. And as the judge puts it, the walls are flush. In other words, there is no gap. Whether there would in practice be a theoretical gap is not apparent from the plans because they are plans for the purposes of applying for planning permission, not plans for the purposes of building regulations.
Well, he says there is no room to infer a gap, or at least not to the extent that the bottom of the gap could be sensibly regarded as the ground immediately adjacent.
Yes. So the first point is my submission is that there is no gap. On the plans, there's no gap. So my learned friend's argument doesn't really get off the ground. But if the court is not with me on that, then what the learned judge is saying is that there's no gap that could be sensibly regarded as the ground immediately adjacent. No doubt echoing the general approach to planning that my lord has cited, that development orders should be construed in a broad or common sense manner. That leads to this point about what is the purpose of the order, and is there a prohibition on having regard to ground which is outside the curtilage. And in my submission, there is no prohibition in the express wording of the order that you shouldn't look at ground outside the curtilage. And secondly, there's no reason for the court to imply such a constraint. The first point to make is that the outbuilding within Class E has to be within the curtilage. Now, in this case, curtilage coincides with land ownership, but that's not necessarily the case, and that's not the case in Burford. So what my learned friend is saying, that if I have a different house, I have a yard and a horse a paddock beyond the curtilage, which, for the sake of argument, the paddock is not within the curtilage. There's no wall, and I would be entitled to build my outbuilding up to the boundary of the curtilage, which is next to the paddock. So at least one part of the roof is next to the paddock. In my submission, the appropriate application of the order then would be to measure from the paddock, not to deem some measurement from underneath the footings or anything of that nature. It's common ground in this case that the only difficulty with this building is the height of the lantern. So the building is within the curtilage of Mr. McGaw's property. Otherwise, that would be another reason for the...
Well, as we understand it, it was Mr. McGaw who built the boundary wall, because as he says in his statement, he was asked to by the neighbour because there was a broken down old fence and various other bits and pieces. And we have assumed, rightly or wrongly, that Mr. McGaw built the boundary wall on his own land.
I wonder whether that is the right assumption, because I'm looking at the plan on page 5, which shows a dotted line halfway.
So maybe maybe a party wall.
So that suggests that the boundary wall was treated as being half on each of the neighbour's land.
Yes, the boundary wall straddles the boundary.
Okay, which is why the circle drawn to measure the from the centre point of the roof lantern goes above the wall, but less than halfway across.
Yes.
Right.
Yeah.
But at any rate, because then half the wall is on Mr. McGaw's land, clearly the building is entirely within his own curtilage.
Yes. But if there was no wall, he would be entitled to build right up to the
boundary.
The boundary.
Yeah.
And as has been agreed during argument, the general purpose of the GPDO is to reduce regulatory burden without compromising visual amenity, and that's presumably the reason why the height restriction is 3 metres if you're away from the boundary and 2.5 metres if you're within 2 metres of the boundary. Where the building is up to the boundary, the neighbour's ground is the most relevant ground from which to assess height, having regard to that general purpose of the height restriction. Because if the neighbour's ground happens to be lower, then it will look more visually intrusive. If the neighbour's ground is higher, than Mr. McGaw's land, it will look less obtrusive. So there is, having regard to the purpose of the permitted development order, there is every reason to include land external to the curtilage as relevant adjacent ground.
And as you pointed out, the land adjacent to the curtilage may be the developer's own land.
Yes.
In your paddock example.
Yes.
So you're not looking at anything to do with a neighbour, you're just looking at land ownership of the same person.
No. So, the argument that it had to be within the curtilage doesn't feature in Honourable Judge Jarman's judgment, and the reason for that, it didn't really feature in argument. So it's a new point. But in my submission, there is nothing in the express wording of the order to say that there is that restriction.
Yeah.
And if you have regard to the purpose of the order, every reason to include land external to the curtilage as the relevant land.
Yeah, right, we've got that point.
I suppose allied to that point is Judge Jarman's point about ground immediately adjacent to this razor thin gap can't sensibly be regarded as immediately adjacent ground. Again, that ties in with the general purpose of the GPDO. Very similar arguments to the argument I made about if the neighbour's land is higher, that's where the neighbour is going to be standing. So that is a rough and ready measure of how visually intrusive the building might be.
Yes.
And I suppose you would say that the idea of a notional measurement point at the bottom of a 1 millimetre gap, a razor thin gap, doesn't really help with the purpose of preserving visual amenity.
No. There's a further point, which I suppose is a discrete point, which is that in my submission, I think is probably common ground, the decision maker should look at any building in the same way, whether there's an application under section 191 for a certificate of lawful existing use and development, or as in this case, applies for a certificate under section 192, because under both you have to look at the finished building. Obviously with a section 191 the building has already been finished. Mr. Nixon didn't do that, which is why I think perhaps we have had this argument that there is a gap based on his paragraph 7. But in reality, if this building had been built, in my submission, no sensible decision maker, whether that would be the local planning authority or an inspector on appeal, would visit this site and look at a building which is flush to the boundary wall and say, what about the ground on the left? In my submission, if it was a notional 1 millimetre, no decision maker applying the guidance or the order sensibly would posit that as being ground. And in effect, that is what the learned judge said, which is why he directed the defendants to grant the LDC as opposed to remitting it to another inspector, because in his judgment, no rational inspector would take a measurement from that point, whether with further construction detail or not.
What do you say about Mr. James's new point about the southeastern corner? I mean, we don't know the facts, of course.
No, I think if one looks at the it only works, first of all, if there's a prohibition against looking at land outside the
Well,
curtilage.
not necessarily, because you've got to get over immediately adjoining. and the neighbour's land is not immediately adjoining, it's separated by the wall, by the boundary wall. So the point still runs, even if you're right about being entitled in principle to look at land outside the curtilage, because you've still got to deal with what the judge says in paragraph 38, which is to say the neighbour's land is the immediately adjacent land. Well, on one view it isn't, because it's separated by the boundary wall.
Yes. Well, I think I'll probably answer that by inviting the court to look at page 5 of the of the plans.
So you're answering my lord's question about southeastern
Well,
corner.
Yes.
I'm not sure what you are. At least, well, I'm not sure what I understand. I may not have understood Mr. James's point correctly, because it's new to us this morning. But I think what he was saying is that in the southeastern corner of the building, there is a point at which the building comes to an end, and because it's looking at page 5, at that point it is slightly set back from the boundary wall. There is some ground, or there will be some ground, between the building as constructed and the boundary wall, which will be the surface of ground immediately adjacent to the building at that point. I mean, looking at this plan, page 5, I don't know quite what it represents in reality, but there is a line which goes back from the wall and then goes north from the wall and then eastwards and then north, slightly northwest again, representing some feature.
Frameless glazing, I think, seems to be the front.
Extent of previously proposed roof light shown in green.
So I think that's the previous iteration.
Okay.
And as I understand it, the frameless glazing is now to be the front, the eastern elevation of the building. But that does bend back on itself to the west, leaving a gap between the southern edge of the frameless glazing and the boundary wall. That, I think, is what Mr. James means by the southeast corner.
So between the southern end of the frameless glazing and the boundary wall, there is some ground which is immediately adjacent to the building. And that is a part of the building at which he says you can measure from the surface of that ground, which is ground immediately adjacent to the building.
It may be that I haven't understood the southeastern corner of the building is on page 5. It's
the end of the solid storage wall.
Yes, it's probably my fault. The difficulty with this is the first, although there is only one story. This is the first floor plan.
Yes.
So there's a solid wall all the way across at ground level. So if we go to page 10.
Yes. So that's actually above. Yes, I see what you mean. At the bottom level, the wall is continuous.
Yes.
All the way. So what's under that little space is wall.
Yeah, well, I think yes, either wall or it's just that the internal floor of
certainly not surface of ground.
No, it's inside the building.
So that may be why the point wasn't made below. Because
May
it's
well
not,
be,
not a
yes.
good point on the facts.
Yes. Yeah.
So 10 is the length of the wall which is immediately abutting the boundary wall.
Yes.
Is the full length, and at 5 what we can see is something which is shorter, but that's inside the building.
Yes, I think it's a continuation of the wall is higher in the western part of the building for storage purposes.
Thank you.
Yeah. So going back to my Lord's point, the question is whether one can say that the land on the surface of the ground immediately the other side of the boundary wall is relevant, because although adjacent, it's not immediately adjacent to the building because there is the boundary wall between it and the building.
Yes, my first answer to that is that it is the immediately adjacent ground, because immediately adjacent to the building is a wall.
Yes, the wall is not ground.
My fallback position, which I needn't bother advancing because of the observations which I think the court have made clear and that didn't attract the learned judge either. But the flip side of that is that if that isn't ground, if the boundary wall is not ground, then you have to look for the immediately adjacent ground, which is, for some parts of the lantern, the land on the neighbour's side.
But that may be all right if all that there is a boundary wall. But what if there's a building? What if instead of there being a wall against which Mr. McGaw wanted to have the flush wall of his new garden room, what if there was a building that was 30 feet long, say? You would go to the 30 feet beyond, would you? And say, well, I'm just looking for some ground. And it doesn't really matter what's between the surface of the ground that I'm looking at and the new building that's going to be erected. I've got to go to the nearest surface. That doesn't sound right.
Well, no. It might be then, construing it broadly, that you would look at because there will be ground in the building next door. You might say
the surface of the ground, though, will it? Or will it? I mean, once you say that a built structure can be the surface of the ground, you seem to be moving away from what appears to be the concept underlying Class E, or the restrictions on Class E.
Yeah, I think Class E anticipates building and then external uncovered ground.
Yes, that's the paradigm case, but we're faced with that's the conundrum.
Yes.
The drafting of the order does not anticipate this kind of case. So,
although it's not a very surprising kind of set of facts.
No.
To have a boundary wall.
So in a way, something's got to give, and what the judge said was, well, immediately has got to give, and what Mr. James says is, well, surface has got to give.
Well, I think what Mr. James is really saying, ground has to give.
Ground, right?
Yes.
Yes, yeah, ground has to give.
And if ground has to give, then my rather unattractive proposition that it's the wall which counts comes back into play. I think with my Lord's example of if there's a building, one answer is, and an answer I put in the skeleton to my learned friends, examples of unfortunate consequences if you don't have this deeming of it being underneath is, in fact, what you would do, you would simply do what perhaps Mr. McGaw wishes he would have done right at the outset now and offset it by 15 centimetres, and then it is your own ground and you control it. But if you were building immediately next to another building, it may well be that the broad and common sense construction in those peculiar circumstances would be simply to take the ground level of the adjacent building, because that is
inside the building.
Yes. Although that wouldn't be immediately adjacent, because I suppose the wall of that building would be in the same position as the wall, the boundary wall in this case.
Yeah.
There may be some intervening structures don't prevent the land the other side from being immediately adjacent, and some of them do, depending on
Yes.
size and nature.
Yes, it's fact and degree, and I think going back to that proposition that these have to be applied in a broad and common sense way. If the court takes the view that the learned judge was wrong to take the adjacent ground as being the neighbour's garden, then I do pray in aid the alternatives I put in the skeleton as being preferable to what, in my submission, this deeming provision really does, which is to say it's not adjacent to the building, it's underneath the building. And in that context, again, there's been discussion as to, well, does Article 1.3 have any role to play in Wales, given that the Class E has been rephrased?
Sorry, say that again. Article 1.3 has no part to play in Wales.
Well, there was a discussion as to whether it has any
yes.
role to play. In my submission, it does.
It does.
It does. And if the court looks at the authorities bundle, is page 21 and tab 5. If one looks at Article 1.3, in my submission, it can be divided really into 3 subsections. So the first, unless the context otherwise requires, then the first limb is any reference in this order to the height of a building or of a plant or machinery shall be construed as a reference to its height when measured from ground level. So that's the first part of it. That still applies in Wales. The second limb is, and for the purposes of this paragraph, ground level means the level of the surface of the ground immediately adjacent to the building or plant or machinery in question. So that's the second limb, which again applies in Wales, and it's only the third limb which has been effectively disapplied, which is that where the level of the surface of the ground on which it is situated or is to be situated is not uniform with the level of the highest part of the surface of the ground adjacent to it. So that part no longer prevails in Wales. But
Can you just explain why it doesn't apply to Wales? Is there some specific provision, or is it an inference from the fact that it's all restated, or parts of it are restated in Class E?
It's.
I think it's a specific provision, is it?
Is that?
It doesn't actually say it's been disapplied, but it's because it's any part of the building would be exceed 2.5 metres or 3 metres when measured against the land immediately adjacent to it. So it's that you look at individual sections of the roof. So if one goes to page 26 of the authorities bundle.
Ah, I see.
It's the use of any part.
Yes. That was the debate before the second inspector, Mr. McCooey. And Mr. McGaw argued that you should take the highest level of the ground, and Mr. McCooey concluded, and his reasoning is that it's at I think tab 28 of the supplementary bundle. It's probably worth having a look at that.
So it's the reference to any part of the building that contradicts or that renders inapplicable the last part of 1.3, under which you can look at the highest. If you've got unlevel surface, you can look at the highest part of the surface.
Yes.
Whereas if you're looking at any part of the building, measured from the surface of the ground immediately adjacent to that part, you've got to satisfy the height requirement all along the outside of your building,
Yes.
proposed building.
That has some consequences as to the natural reading of that, because if you take a section in the middle of the roof, that is not going to be immediately adjacent to any ground which is external, because it's going to be 2 metres away from the boundary of the or the flank wall. But again, I think that's a question of having to construe it in a common sense fashion, so that it's the land which is closest to any particular part of the roof. The only other submission I wanted to make was to draw attention to the concession made by my learned friend at the outset about the offset building, the 150 mils from the walls, being subject to questions of artificiality and it being a device, being within the height restriction. Like primary cases that the court should uphold the learned judge's decision. But my fallback is that it would be useful if the court were to make observations as to that concession, as to that third application for an LDC.
Well, I'm not sure that we would do that. It's not before us. And
no.
Speaking for myself, although I have looked at the plans, I haven't really thought about them, and we haven't really heard submissions.
No. Very well. My lord, there's nothing else unless there are questions. Well, I
think you're getting a prompt, Mr. Jones.
Yes. Yes, thank you.
Thank you very much. Do you wish to reply, Mr. James?
My lord, very briefly, I have 3 points. The first relates to Article 1.3 and its application. I do say it applies. However, height, or the definition of height, or how one arrived at the measuring of height, as is set out in Article 1.3, is of course contained within Class E in any event.
So you say that all three, what Mr. Jones calls all 3 limbs?
Not all 3,
Not
apologies.
all 3, right.
Everything up until...
the first 2 limbs.
My lord, yes.
Yeah.
The importance of Article 1.3, however, is unless the context otherwise requires, because the definition of height and the definition of ground level is essentially contained within Class E in any event, and so one doesn't need to look from Class E to Article 1.3 to find out what do I measure or from where do I measure. And the real benefit, or the real significance of that in this case, is significant respect therefore should be given to Class E as a regime in respect of dwelling houses, within developments within the curtilage of a dwelling house. Secondly, my learned friend puts it that on my case it is the ground that gives way. My lord posited in the sense that it is the surface that gives way. In my submission, it can't be the ground that gives way, because if there is a gap, then there is ground there. There is something there. It can't be said that it's the ground that gives way. I'm bound to accept that the usability of the ground gives way, and that...
You say it doesn't matter, it's only a point from which to measure.
My lord, indeed. But I don't say that the ground or the surface to a material sense falls away on my argument, so that it is irrelevant to the purposes of Class C. It's the usability, but that's irrelevant. It is ground, so it may be measured from that location. And the final point, just dealing with the circumstances or the situation that was put to my learned friend of a building being next door, it would be curious if the order were to allow the internal ground height of neighbouring property to be considered before either the internal ground height of the development or deeming some ground level. And the question there in my submission really is one of hierarchy and what does the context require? Does the context require that the order looks at a deemed height or calculates a height, or does it require, in the circumstances put to my friend, that rather the context rather requires looking at the ground level of the neighbouring building? And I say that's unlikely to be the case.
But the upshot of your case, as I understand it, is that the measurement should be taken from the base of the boundary wall on Mr. McGaw's side.
Yes. That's right, because there is a gap, and that, I say, is a complete answer.
Yeah.
If you are with me that there is a gap, even a nominal gap. My lords.
And if that produces a height that is not within the scope of Class E, you say Mr. McGaw's remedy is to apply for planning permission?
Yes, or alternatively to, if the intention is to build as per the plans that were the subject of the application for Mr. Nixon, yes, or alternatively to redesign in the manner which has genuine land or doesn't fall foul of any artificiality with backfill. But those are options, but they don't assist Mr. McGaw in this appeal, I suppose.
That's probably an irrelevant question. Is there some policy in the development plan that would stop Mr. McGaw getting planning permission for this? Well, why are we going down this route rather than simple application for planning permission? Perhaps I should have asked Mr. Jones that question.
Yeah, I think it's.
He may well regret that he didn't do so years ago.
I don't think that's a question that I can answer.
Right.
Certainly, as far as I'm aware, there's no reason why a planning application couldn't be made. Of course, ordinarily this route is the easier route.
Yes.
The simplest and cheapest.
Not in this case.
My lady, yes, but as matters have transpired, there's no issue in principle why that application couldn't be made. And perhaps I ought to say, for completeness' sake, the availability of that, or any suggestion that there is an absurd result by the application or the interpretation that I invite your lords to adopt, that doesn't, I say, lead to, if you're with me on there being a gap, that being incorrect, or the circumstances requiring that interpretation to be departed from. My lord, my lady, I think I've said enough on that.
All right.
Unless there's anything else, those are my brief points in reply.
Right. Well, thank you both very much for your very succinct and compelling submissions. We will reserve our judgments. You will get a draft in the usual way, which will be your opportunity to correct any obvious typos or factual errors. We would hope that in the light of the draft judgments, you will be able to agree a form of order disposing of the appeal. If you can't agree the form of order, please make short submissions in writing and we will make the order, I think, appropriate. Thank you both very much.
Court rise. Live stream off, and on stream and broadcast for 90 seconds. So anything you say will be broadcast.